Good morning and welcome to our Briarwood Center here, the Christ Lutheran Center. We're glad that you are here this morning for this. I think we're live streaming as well. Get on stage. The camera doesn't catch me if I'm there. Is that better? Okay, very good. Thank you. Maybe it's a light issue. My name is Kevin Knaus, and I serve as Bishop of the Northern Texas, Northern Louisiana Mission Area of the Evangelical Lutheran Church in America. And we are very pleased to be able to present this event to you today from Texas Impact. They will give you all the background on what it is that we need to hear and what we'll be thinking and talking about today. But we welcome people of many different church backgrounds. And I want you to know this is not so much a Lutheran event, it's just that we have the opportunity because of our connections to present this to you today, and we're glad to do that. We want to begin with a prayer, word of prayer. Let's pray. O Lord God of all time and space, we give you thanks for this day and the gathering of people who are here in this place. We come from many different faiths and many different walks, and yet we all yearn for peace. We all yearn for safety. We thank you that there are those who are speaking publicly on our behalf and helping us understand how we can promote peace within our congregations and in our places of worship. We ask that you would be with us in this gathering and that you would help our presenters to lead us well. Amen. All right. Okay, so I'm going to turn it over at this point to our speakers from Texas Impact, and I knew I wasn't going to get the names right. Beeman Floyd, are you going to be the first one to speak? Okay, and then our second presenter is Joshua Houston. There we go. Okay, Beeman or Joshua, come on up here. I'll let you take it from here. Please welcome them.
Thank you. Thank you. My name is Beeman Floyd. I am here today representing Texas Impact. Texas Impact, how many of y'all are familiar with Texas Impact and its work? Okay, Mel is, because he sits on the board of directors. Texas Impact is an advocacy group in Austin. It's an interfaith group. It is a 501c4, which means that it is a nonprofit, but it also means that it is allowed to go down to the legislature and advocate, lobby, if you will, the legislature. We've been in existence since 1973. I have fabulous support today. 1973. It has grown tremendously in the last decade or so. What we have discovered is that Austin, in general, and the legislature in particular, are yearning for representative voices. They need to hear your voice and the voices of the faith community as they consider public policy. And increasingly, public policy and religious organizations and faith organizations are intersecting in a very energetic and sometimes entertaining and usually scary way down in Austin. We work on a variety of kinds of legislation. We work on faith issues, on religious freedom issues, on environmental issues, on social justice issues, certainly healthcare, criminal justice. We find that our portfolio is actually quite broad because the interests of the faith community are very broad here in Texas. We also find, as you might expect, that we have real challenges speaking in the halls of the legislature. We are a true live grassroots shoestring in a comparative way organization compared to a lot of the advocacy organizations in Austin. And so no complaints. It is super fun and we really enjoy what we're doing. We have several staff members here today. Sean Hannigan, also known as Irish Sean since he grew his red beard, works with our IT and does a whole lot of work for us in the electronic world of information gathering and witnessing the internet, which is really important. He is able to put together a lot of materials for us that summarize the legislative session and the activities that really shed light to the broader public on what's going on in the halls of the Capitol. Sam works with our Water Captains Project. We are very strong into the water issue now at Texas Impact. This has become, obviously, as you guys know, as much of anybody, as anybody, Texas is a very crazy place for water, feast and famine. I guess you recently had a pretty bad feast of water here. But the question is, what do you do with it, and how can you manage it better so that, like Joseph in the Bible, you even things out? Scott Atnett works with our Community Partners Program. He goes around the state and encourages people to learn how to interface with public projects and public programs for the good of those in your community that need that help. Very important. Sadia Tirmizi, I always get her the pronunciation of her name wrong, works specifically on membership. So if you are interested in what we do further, she is most definitely the person that you need to talk to. And Joshua Houston is General Counsel, Texas Impact. He does absolute point work in the Capitol. He is the person who gets up and is the witness at the Capitol on behalf of the faith community. So he takes the oath and takes the mic and takes the beating from time to time that has to be taken down in the Capitol if you're going to represent these issues. My name is Beeman Floyd. I am outside legislative counsel for Texas Impact. So I am a public affairs consultant and lobbyist in Austin that works with Texas Impact on the wide variety of issues. Texas Impact has a sister organization, the Texas Interfaith Center for Public Policy. This is a 501c3, and it is devoted to research, good quality, rational research on these issues. Its job is to survey the issues that are important to the faith community and to those people that the faith community serves, and to come up with really good quality research on those issues. The issues that I have described that Texas Impact works on in direct advocacy, the Public Policy Center works on with regard to study. And it helps develop the agenda that then Texas Impact is allowed to go to the Capitol with and lobby the legislature. Does that make sense to everybody so far? Okay. We were minding our own business a few years ago, and suddenly all became gun lobbyists. And we became gun lobbyists because I think, as all of you know, in Texas, guns have become not just a tool for taking a heavy piece of metal and making it go real fast in a straight line, but guns have become a political issue and a social issue, and in many respects an ideological issue here in Texas. How many of you have looked at the websites of Republican legislators or Republican candidates for the legislature? One of the very first thing you will see is their grade from the NRA, right? And I'm not saying this in a partisan way. I'm saying this in a strictly observational way, that a grade from the National Rifle Association has become a very, very important thing. When you are running for office in Texas, it behooves you to fire a firearm on camera and then have the film of that available for people to see, because shooting a shotgun makes you a better Texan. I'm not sure if you all knew that, but it's true, right? Guns are part of Texas culture. Guns are a long-time part of Texas society. Guns in the recent times have become a big part of political society in Texas and in the United States. We are here today to talk about what that means in terms of the current law and in the law as it will change in January. We are not here yet to talk about the ideology of guns and the political view of guns that we have in terms of the law. We're here to talk about the laws that exist and what you can do and what you have to do and what you should do and what you can't do related to guns in your places of worship. it's already a difficult issue, right? We've already seen sort of demonstrations of firearms carrying related to places of worship. And we think we're going to see more. So, as we have talked to congregations, we have also discovered that there is a tremendous amount of confusion about your obligations and your responsibilities and what you can and what you can't do in the context of firearms. The law has been drafted and the law has been passed primarily from the point of view of people who are very interested in enhancing and expanding Second Amendment rights as they see it, which means that there are a lot of duties placed on those people who would choose to limit or abridge or create boundaries for those rights. And that is where we are today. So the purpose of today's meeting is to talk very specifically this morning about the gun law as it exists, the gun law as it has existed since 1995, the gun law as it will exist after January 1 of this year, when we will suffer the particularly large change of open carry becoming legal for CHL holders. And we'll talk about what all of these things mean and what the choices and options that you have in your places of worship to work in these changes. I will tell you on a personal note, I am sitting on the task force at my own church, Shepherd of the Hills Presbyterian down in Austin, and have been surprised already by the feedback that we have gotten from the congregation. We have experienced persistent confusion, but more than that, we have found out a lot about our congregation that we didn't know. First and foremost, that we are experiencing a tremendous amount of pushback from people who for years and years have had CHLs and have carried weapons in church, and nobody has ever thought about it. We've had concealed weapons legal in Texas since 1995, if you are a permitted carrier. And we have existed, if you will excuse the reference, in a state of don't ask, don't tell. How many of you currently have state-authorized, state-compliant signs posted forbidding the carrying of concealed weapons in your places of worship? Right. Since 1995, any one of your parishioners who has bothered to go and have a CHL, any one of the members of your faith community could have been carrying a concealed weapon in worship. And if they're doing it properly, you don't know it. And you haven't known it. This issue is causing us to find out some of who those people are and their real commitment to carrying those weapons. So it's not just as easy as there's a lot of communication, I think, that is necessary in the faith communities to talk on this issue. I found out two things. One is that a bunch of people are carrying weapons in my congregation and are worried about not being able to do that anymore as we discuss this issue. The other thing is there is a general assumption in my church that I am carrying a weapon, and I don't know why that is. I don't know why that vibe is out there for some reason. People say, well, you carry one, right? And I'm like, what are you talking about? I certainly do not. But it's a strange thing. We find things out in these things. So what we'd like to do today is, one, get you thinking about how you're going to communicate this to your faith group. It's pretty important, I think, to have a good, robust conversation and not to make assumptions about what your faith group is going to think about this. And the second is to really make it so that when you are discussing this with your governing bodies or councils or whoever makes decisions in your faith group, that you absolutely understand what the law is. This is critical because, like I say, our experience is that people's perception of this thing is all over the place, and we're really here more than anything today to make sure that when you go back to your community, you have an absolutely clear understanding of what the law really is on this. Are there any questions about that framing? All right. Joshua Houston, as I said, is our general counsel. I will brag on him a little bit because he won't brag on himself. I say with confidence that he is the foremost expert on this issue in Texas right now. He's been working on it since the legislative session. We have discovered all manner of people in the legal community who have had an unclear understanding of this thing. That being said, part of what he will tell you today is stuff that he doesn't know because we don't know, because this law is so new. There are a bunch of vague parts in it that haven't been litigated yet. So we can't bring you absolute certainty, but we can bring you the absolute best available knowledge that we have on this law and the way it affects faith communities today. So, Josh Houston.
Good morning. I'm going to kind of roam around this side of the podium if that's okay. I have some notes that I need to follow and I need to drive the PowerPoint. I'm Joshua Houston. I'm General Counsel to Texas Impact. I'm also Director of Government Affairs. It's a pleasure to be here today. Thank you for coming out here. It's a beautiful place. I like to start off by saying I'm going to tell you a whole lot of legal information. But in the back of your mind, the legal is important, but in the back of your mind, you need to remember that ultimately what you and your congregation have to decide is a theological question about how you want to go forward with guns in your congregations. It is our job to make, in the Lutheran Church, it's your social statements, and the Methodist Church is called the social principles. All of our member denominations have positions on issues. It is not my job to be the theologian for you. It's actually the reverse. It is your theology that informs our work, and we try to make those social statements and those social positions real in the world, and that's what Texas Impact does. So ultimately, what you've got to go back and have is a theological conversation. I hope to provide you is the legal background from which you can go back and know what the legal framework is so you can make those theological decisions on your own. The second thing I'd like to stress before going forward, while I'm going to give you a bunch of legal information, when in doubt, if you have a situation that arises in your congregation, when in doubt, call the police. If you have any doubt about a situation that's arising, call the police right away. There's a lot of things in the news that you can probably think of that would make you want to do that. The third thing, as Beeman said, my job is to go lobby at the legislature and take the legislative buzzsaw, as you will, from the committees that will sometimes be mad that you're opposing their bill. There was a bill last session that did not pass that we worked on that would have, it said if you took public money of any kind, state, federal, local, then your, as a property, could not prohibit guns on your private property. And I had to go inform the legislature that, well, in the Methodist Church, we're hierarchical, and we do a lot of disaster work. So if we get money from FEMA to do disaster relief, does that mean that our ministries that involve children or domestic violence and all those properties that we also own are suddenly, we're unable to control weapons on those properties? And that bill, fortunately, never saw its way out of committee. However, the bill that we're here to talk about today is House Bill 910. That is the open carry law that is now going to be law on January 1. That bill did pass, and that's the bill that we're here to talk about today. Little background, as Beeman said, for 18 years, we've had to post notice if we wanted to prevent concealed carry. Back in 1995, everyone predicted a lot of mayhem from CHL holders that frankly never materialized. And so while guns is a thing that creates a lot of emotions on both sides, I want to make sure that we just kind of approach it soberly and make rational decisions as we move forward in making these policy decisions for our congregations. The difference now, obviously we've had concealed carry for 18 years. The difference now, and while we're here talking about it today, is that with open carry, what we mean by that is that it can be visible. It can be worn openly where you could see it, like a law enforcement officer or like your images from the Old West. And when it's visible, it forces a conversation. It's a conversation piece, if you will. It is no longer out of sight, out of mind. And your ushers, your greeters, whatever you title the people that often greet people at the door and make them feel welcome, are going to be the person that encounters this. And you're going to want to make sure that they know what your policy is and how to handle the situation. You don't want them taken by surprise. And so while it is very unpleasant to have some of these community conversations, it can be divisive if you don't handle it in a very diplomatic way within the congregation. It is better to go ahead and do it because you don't want those ushers and greeters put in a situation where they're surprised and they don't know what to do. My little legal disclaimer, I'm not your attorney specifically, but providing general education on the law. This is the protect myself sentence. My title is general counsel. And in other words, what that means is I'm kind of like your primary care physician. I'm not an orthopedic surgeon, if you will. And so I have consulted with other attorneys beforehand. Some of them are actually attorneys that represent your denominations. In the Methodist Church, we call them chancellors. They're attorneys that represent the denomination directly in things that arise. We've been in consultation with law enforcement. We've been in consultation with prosecutors that we know. The prosecutors have a lobby the same way we do, that my counterparts. So we've tried to provide the best research on it that's out there. But there will be specifics that arise for which you'll need a specialist. And when we don't know what those are, I'll point them out to you, and we'll kind of get into that towards the end of the presentation. I'm going to ask that you hold your questions to the end. I'm going to ask that because we are live streaming. I want to make sure that we don't have a chaotic thing for the people that are watching online at home. If you are at home and have a question, then you can email Sadia, and I'm going to provide her address right now if you can get a pen and paper. Sadia's email address is SADIA, so SADIA at texasimpact.org, and Texas is spelled out TEXAS. Oh. Oh, terrific, thank you. Yeah, so we'll be able to have a robust Q&A. We've done this presentation a few times now, and there's always a whole lot of questions. And we'll spend a lot of time doing that before we all break for lunch. I also predict that the presentation is likely to trigger new questions. So that's another reason to kind of hang off, and we'll do it at the end. Our goal today here is to all leave here confused on a higher level. That's the best I can offer. We will all have more information, and my questions will only serve to produce more questions, and we're all going to leave here confused on a higher level. I'll tell you that we're on what is kind of a legal frontier. And where there is frontier, there is ambiguity, and that's why people like lawyers like me have jobs, is we make our living off the ambiguity. I try to provide clarity in my line of work as opposed to some of the litigation end of it, but we all have different roles. I'm general counsel to a small nonprofit. My philosophy in general is to avoid litigation always, because litigation is expensive. I've learned that even if you are legally right, establishing that in court can be very expensive and unsatisfying in the end. So my goal is to always avoid that, especially since congregations are also small nonprofits. That is a thing to always avoid. As we get started, I want to be real clear on the categories of what we're talking about and what we're not talking about. So the first category is carrying in public, which is what we're talking about, versus possession in your home. We're not talking about possession in home today. That's a totally different thing. We're talking about people allowed to carry in public. So where can you carry in public? If you do not have what is now called a handgun license, it used to be called a concealed handgun license, CHL. Now it's just called handgun license after the passage of House Bill 910. If you do not have a handgun license, then you can carry on your own property, you can carry in a motor vehicle, and you can be directly en route between those two. And you can do that so long as it's not in plain view and you're not committing some offense. You would think that would be obvious, but it's not always. With a CHL, with a handgun license, anywhere so long as, you can carry it anywhere so long as, then there's certain places where it's prohibited. So there are places where all weapons are prohibited. These are schools, These are polling places, a court, a racetrack, an airport, or death row in Huntsville. They had a problem out there a few years ago. So those are places where all weapons, firearms, long guns, everything's prohibited. That's also not what we're here to talk about today. What we are here to talk about is places where handgun license holders are prohibited from carrying. And this is found in 46.035. We'll get into that statute here in a second, but there's 6 places: bars, sporting events, correctional facilities, hospitals, amusement parks, and houses of worship. What brings us here today, houses of worship. What are we talking about? We're talking about handguns only. We are not talking about what are called long guns, and these are rifles and shotguns and antiques before 1899 and black powder, but we'll just say rifles and shotguns for simplicity's sake. So we're talking about handguns only. Long guns are different, and this distinction is important, and we're going to return to it a little bit later. So we're immediately talking about handguns only. Who can carry? So there are those who like to say the term gun-free zone. There is no such thing. It is a term that is used by people, often the pro-gun side, that will use it in a pejorative way to make you feel vulnerable about a place. So let me back up and say, let's make sure we're clear on who can carry no matter what. And these are any peace officer. That's state, it's federal, it's local. It's whether they're on duty or off duty. And there are 36 different categories of peace officers. So obviously your city police, your county police are the ones you think of, but it's actually broader than that. It includes, like, hospital districts can have peace officers. You can have officers commissioned by boards of pharmacy and dental examiners. There is a very broad category of peace officer in the Texas Code that can carry anywhere, anytime. There are 19 categories of special investigators who can carry anywhere, anytime. Most of these are your federal agents. It's your alphabet soup of CIA, FBI, Homeland Security. These are federal police officers that can carry anywhere, anytime. Private security officers can carry anywhere you have a contract with them. So if you have a contract with them, they can carry no matter what. And also retired police can carry, so long as they're up to date in their certification, and they know that. They know what that certification is. Judges and prosecutors can carry pretty much anywhere, anytime. So there are really no gun-free zones. It's not a thing that exists. What we are talking about today is the handgun license holder and whether or not you want a person from the general public that has gone to a 4-hour training and been able to hit a piece of paper from here to this wall, give or take, enough times to pass the test. There are 800,000 of them in the state. The odds are is you've had somebody walk in your church that this has probably happened already in 18 years. The question is, do you want to allow that? Do you want to allow it under what circumstances? Do you want to continue to allow it if it's concealed? Do you want to allow it if it's open? These are some of the policy questions you're going to have to ask yourself. Legislative history of how we got here. In 1995, we passed our first concealed law. It was Senate Bill 60, and it created the part of the code we're going to talk about. Churches in this original bill, this original law from 1995, churches were originally off limits entirely. So for 2 years, they were off limits entirely. Then in 1997, there was a cleanup bill. And as a lobbyist, cleanup bills always make me nervous because they often make substantive changes through amendments, and you have to watch those things like a hawk. And sure enough, in 1997, and that's what happened, on the very last day for the Senate to pass a bill, so about 3 days before sine die, a floor amendment was put on House Bill 2909, which added subsection I, and we're going to look at what that is in a second, but what subsection I does is it forces you to post notice. So it forces churches to take an affirmative step to prohibit weapons, as opposed to the way the law was 2 years before that, where they were just off limits entirely, and that was 18 years ago. In 1999, one of my mentors, a man named Phil Strickland, who worked for the Baptist version of Texas Impact, tried to fix this. That bill never got out of committee. It was politically just impossible to get it through in 1999, and it's just as hard today, politically speaking. And of course, this last session, so largely unchanged time periods for 18 years, the law has largely been unchanged until this last session when they passed House Bill 910. So let's look at the code real quick. This is a thing that confuses a lot of lawyers. So if it confuses a non-lawyer, don't feel bad, it confuses lawyers too. So the original language in 1995, it looks like churches, hospitals, and amusement parks are off limit entirely. If you just read subsection B, it says a license holder commits an offense if the license holder intentionally, knowingly, or recklessly carries a handgun on or about the license holder's person on the premises of a church, synagogue, or other worship. So on the surface, it looks like no guns, and that's because that's the way it was originally written. You have to keep reading about another page or two down in the code to come across the subsection I. And subsection I reads, if subsections B4, B5, B6, and C do not apply if the actor was not given effective notice under 30.6 and 30.07. So it's the most convoluted mess. I mean, is it well written? No, it is terribly written. Sections 30.06 and 30.07 are for private property generally. 30.06 is the concealed that has existed for 8 years. 30.07 is the open that they just added in this last bill. So it is this most circular, reference to this part of the code, to read this part of the code, to read this part of the code, to read this part of the code. It is a hard, poorly written statute that is confusing to a lot of people. The bottom line is, if you want to prevent, you have to take an affirmative step, and we're going to talk about what that is. So the affirmative step you have to take is effective notice. What is effective notice? And the code tells you what that is. So in 30.06, trespass by a holder of a license to carry a handgun, this is the private property provision. A person receives notice if the owner of the property or someone with apparent authority to act for the owner provides notice to the person by oral or written communication. So let me break this down for you instead of reading the code to you. 3 kinds of notice that are effective. There's oral. So in other words, me walking up to you and saying, sir, I'm sorry, our policy is not to have that here. That is a form of notice. The other way is by a written card. So I have cards made up and I say, sir, I'm sorry, we don't allow that here. Then the third way is written through a sign, through a posted sign. Either of those 2 written forms, the card or the sign, require what I'm calling magic words. By magic words, I mean the statute says it has to be identical to what is prescribed in the statute. The statute also says it needs to be in English and Spanish. The letters need to be 1-inch block letters, and they need to be displayed in a conspicuous manner. And we're going to walk through this with you. But for right now, if you're curious how big 1-inch block letters makes the sign, this is how big the sign ends up being. With 1-inch block letters, exactly the same words in the code in English and Spanish. It was meant to be huge, and it was meant because they want to deter you from doing it. There's really no other explanation for why the sign is this big, especially when you have all other kinds of signs on buildings. There's really not much any other explanation. It is okay to add language to the sign. So this is all, we have them, we knew this would be challenging, and so we worked with the prosecutors to design a sign. We had them look at what we did and say, yeah, that's enforceable. And then we contracted with Build a Sign to try to lower the cost, because this is going to have a cost associated with it. We wanted to find a way to make it as economical as possible for those who wanted to, if you so choose. You can add language to the sign. This is customizable. We just put that there for example's sake. Obviously, a lot of churches have their own logos, they have their own statements, they have their own theology. If you want to add to it, you can. But you cannot subtract and you cannot alter. This is a 3007 sign. This sign would prevent open carry. It would not prevent concealed carry. If you wanted to prevent concealed carry, you would need a second sign. This one is a 30.06 sign for concealed carry. Do you need both of them? Yes. A rational explanation is that they wanted to provide you flexibility to prevent open but allow concealed, or prevent concealed and allow open, or allow both, or prevent both. Another rational explanation is that this takes up a lot of real estate and you won't want to do it. I don't know. You can decide for yourself on that one. But let's look at the magic words. So in 30.06, nobody raised their hand in here that their church had already done this. Some of you online, there might be one or two. I have not really a lot of congregations who have done this. But if you have an existing 30.06 concealed carry sign, you need to get a new sign. So on the PowerPoint, I have certain words that are underlined. If it is underlined, that is the new language that has to be identical. If it is struck through, that is the old language that is no longer good. And come January 1, the old sign will no longer be enforceable because the language is not identical to the new language. So you'll need a new 30.06 sign if concealed is a thing you want to prevent. There are also magic words for the open carry. And of course, the reason you need two signs is that you can prevent one and allow the other. If you want to prevent both, you have to post both. That is what the general consensus is from DPS, from prosecutors. That is the general consensus in the law enforcement community because it says identical. In case you're curious, there are fringe groups that are challenging people's signage. Now, I don't want to disparage the pro-gun community. There is a subset of that community, that's why I call them fringe, that are actually actively challenging these signs. For the most part, they're not picking on churches. I have not seen anybody do that. They're picking on places like Starbucks and Applebee's that are posting. They're focused on government buildings because there was some change in the law to how government buildings can prevent and not prevent. But if they see an improperly posted sign, they will walk in and challenge it. It's just a thing to be aware of. Often they have video cameras with them because they're trying to make a political statement. Like I said, I've yet to hear of this happening in a religious community. Although we are, our Muslim friends in Irving right now, if you've read the newspapers, are having some serious issues. But that is with open carry and with assault rifles and long guns, and we'll talk about that once we get through the handgun part. That is not actually connected to House Bill 910. That is a thing that's been already in the law. So the question you now have before you is to post or not to post. That is the decision you'll have to make. So what is the advantage to signs over other forms of notice? A signage like this avoids confrontation. You've not put your ushers and greeters in the position of having to make a confrontation with somebody. It's a shortcut for the police. So we did this event in Austin. We had Austin PD come out and kind of talk with us a little bit about it. And what they told us was that the sign makes their job easier. And here's the reason, is that when you go to court and try to get a conviction, you have to prove that the person received notice and that notice was effective. And so if it's just an oral statement, you then have to witness. If it is a handwritten card, you still have to produce a witness that said, I gave them that notice. And most of the time, the police don't want to rely on a witness showing up in court. They would rather just issue a warning, and then it's in their system, and then they tell the person. So even if you walked up to them and said, sir, you need to leave, and then you call the police, or sir, here's a card, this is our policy, and then call the police. When the police show up, and it's highly likely, like Austin PD said, what they would do is write a warning and then the person would have to depart by warning. What the sign does for the police is there's no question about notice. There's a sign, take a picture. So they make an immediate arrest. That's a question you'll have to decide for yourself, whether you want somebody who does this to be immediately arrested or issued a warning. So that is one of the things that police like about the sign, is that they can see it, they can make a decision, it makes their job easier. The other thing about a sign is that the officer told us is that they have beat cops who know their neighborhood. And they know the buildings in the neighborhood, they know the places in the neighborhood, that's their job. And so if they know a sign is posted on a particular religious community, and they look for them, I mean, they're driving around and they look for things like that, and they know their little neighborhood that they're supposed to patrol. If they know a religious community has a sign, and they get a call, and that call comes in saying there's a gun at that particular religious community that has a sign, they psychologically come with a different frame of mind. So instead of coming in investigating the situation, they come knowing the situation, and they come knowing that they've got a problem. And so it affects their response and how they're thinking about the situation when they respond. So they say it makes their job easier. Obviously, there's some other considerations for religious communities. One of the problems with oral notice is this apparent authority. So oral notice requires that someone with apparent authority to act for the owner deliver that notice. In a church setting, who has that? Obviously employees, but in a church setting you have ushers, greeters, volunteers. They can be given authority, but that's an ambiguity that's going to make the prosecutors and the law enforcement's job a little more difficult as they try to sort out whether that apparent authority existed or not. And of course, the more important question is, do you want to put your people in that role? Do you want to put your ushers and your greeters, who are often volunteers, in that role of being the primary confronter? Whatever you decide, make sure they know what the plan is. If they are the first people to encounter an individual, they need to know the plan, because you don't want a lot of confusion in a situation like that. I mean, this is a difficult question, right? I mean, for a church community, what if it's the harmless old crank that we all know? You know, do you want the police arresting, George, who's been coming for years, and now that the law has changed, decided he wanted to carry his gun openly, and he's been carrying concealed for years? And I mean, it's an interesting question, right? Do you want to have harmless George arrested? But then again, what if it's someone you don't know? A complete stranger? Or what if it's someone who you do know that, you've been in pastoral counseling with, and you know that there are some issues there in their personal life? I mean, these are really difficult questions for a faith community. And so that's the danger of oral notice, is that, you can get that. So another danger of oral notice is the conflicting information a person gets. So say it's the harmless old crank, but he gets conflicting information. What if greeter Betty Sue says, "Oh, it's fine, come on in," and your other greeter says, "Oh no," and calls the police? I mean, that's why it's just good to have policy in advance and not have to deal with that. So what is a conspicuous manner? How do you provide notice in a conspicuous manner? A way to think about this statute is it's a subcategory of trespass. And with trespass, you have to receive notice and not have effective consent. So in other words, you can post a no trespassing sign on your property, which is kind of what this is. You can think about it like that, and it keeps the world out. But you can provide consent for somebody to come on your property. So those are the kind of the two elements of trespass. But the question that often arises is, so does this mean I need a sign at every single entrance? And so this is a common situation in churches where you have, 3 doors. And a question that often I get is, does that mean I need 6 signs? No. The law says conspicuous manner. And so I think 1 sign in the middle of one of those 2 doors would do you. The question, and this is a hard question, is a conspicuous manner. It is a thing that's going to get left up to a jury. And so a good rule of thumb, if you decide to post notice, and you're looking at your church, and every architecture is a little bit different, but a good rule of thumb to keep is if I was sitting on a jury and a prosecutor showed me that picture, would I think that that sign is conspicuous? Would I think beyond a reasonable doubt that was conspicuous enough for me to, convict somebody? And that's just a good rule of thumb as you're trying to decide on each particular building, which is each designed in its own special way, whether or not that sign was conspicuous. Another rule of thumb, think about your security procedures. If a door is like a fire exit only door, it is not open to the public, you probably don't need a sign there. But if you open it on Sunday morning and Sunday morning only, and the public could enter, you probably need a sign there. And so this is an opportunity to kind of think about your church or synagogue or mosque layout and really think about, how do we want people coming and going? Do we really need all these doors open on Sunday morning? Do we want to control traffic in one way? It's just a time to kind of think about all that. And it's unfortunate that we have to think about all that. In a way, the Christian community has been privileged for many, many years. And this is a thing that our Jewish and Muslim friends have had to think about for a while. There are also doors that have codes that certain people can enter. That's a fuzzy gray area. If you want to be belt and suspenders, post a sign. If you think that only the pastor or the employees can enter it, well, you can roll the dice. It's kind of a community decision you'll have to make on how belt and suspenders you want to be with something like that. And just as a periodically check to make sure the fire exits aren't propped open. That's just kind of a general security thing. If you want to make sure that somebody hasn't propped the door open, just kind of keep an eye on that sort of thing. So there are differences between chapter 46 and and some of the private property statutes. We've talked about this a little bit. So 46.035 is the part of the code that churches and other properties are under. Some specified properties, if you will. 30.06 is the statute that all other private property falls under. They are different. And so there have been legislative attempts to strike 46.035 from the code. And we object to that bill every session. And they say, well, you're still private property. You're covered under 30.06. And I say, no, there are some significant differences between the two statutes, and we like having an explicit provision. Here are some of the differences. In 46, there's what's called a mental state. So all the prosecutor has to show is the person was reckless. Under the trespass statute, you have to show entry, receive notice, and without effective consent. They're different. But the biggest one is the penalty. So one of the things that changed in House Bill 910 is that if you enter one of these specific places, it's a Class A misdemeanor, which is the most severe misdemeanor you can receive. The reason that Class A is important is because if somebody is convicted under it, they could go to jail. As an option for the prosecutor, there is a much larger fine. But the most important thing is that the handgun license is revoked. And if somebody's violating the law and doing it in a serious way, that handgun license should be revoked if they carry on a place they shouldn't. And it's their duty. When you take the class, they teach you where places you can carry and can't carry, and they're looking for the signs. The 800,000 people who have it have been trained to look for the signs, and if they disregard one, it's your private property, and they should have that license revoked. Class C, by contrast, is like a traffic ticket. It is fine only, it's only $500, and you do not get a revocation for it. So there's a few properties you're going to have to think about. Just a few. This is breaking every rule of PowerPoint. Do not put a slide this busy. I do it intentionally, though, because these are all the different kinds of properties religious communities own. You have foster homes, group homes, addiction treatment centers, pregnancy crisis centers, domestic violence shelters, camps like this one that we're at, student centers, conference centers. We have a ton of properties we're going to have to think about, and each one is different. Each one is going to have its own considerations for whether or not you want to allow this or not. You're going to have independent nonprofits as well, like Lutheran Social Services or Baptist Child and Family Services or Texas Impacts Independent. You're going to have subsidiary nonprofits where you'll have like a ministry center, but you spun the ministry center off into its separate 501c3 so it could get foundation money. And I mean, but they're located on the same property as the church. You could have a homeless ministry on one wing of the building with a preschool on the other wing. There are all these kinds of things you have to consider about the property that we're going to have to think about. And one of the things that makes that really complicated is the definition of premises. So the legal definition of premises is a building or a portion of a building. The term does not include any public or private driveway, street, sidewalk, walkway, parking lot, parking garage, or other parking area. So when you post notice or provide notice by other means, it only applies to the building. It does not apply to the walkways between the buildings. It does not apply to the parking lot. And this is a major problem for the faith community. So when they wrote the premises definition, they really didn't have the nature and character of faith communities in mind. They had a big box store like Best Buy or the grocery store or something like that in mind, where there's parking lots in a building and you park your car, you go to the store, you buy your thing, you come back out and you go home. That's what they had in mind when they wrote this definition. The problem for us is the character and nature of our properties are wildly different. We have basketball courts on the parking lot. We have playgrounds. We have courtyards and outdoor spaces and gardens and labyrinths and all kinds of different properties that they just didn't have in mind when they wrote this definition. And it is our private property. Is this constitutional? Is it commandeering your private property? Since I'm with the Lutherans, I'll tell you, the Lutherans and your brethren in Minnesota didn't think so. So other states have a similar provision, like this provision of premises, where it's building only, no parking lot. And the Lutherans in Minnesota got really mad at this. They also got really mad that they had to post a sign at all. They challenged it in a Minnesota court under their state constitution, and their state Supreme Court agreed. They struck down it as unconstitutional, and their rationale was that it violated their religious freedom. And the Lutherans made a really novel argument. They said, we're Lutheran. We nailed the 95 Thesis to the church door. Therefore, nailing messages to our door is an important theological thing for us. And you are forcing us to post a message that we don't want to speak on. And the Minnesota Supreme Court agreed. Would that work in Texas? I have no idea. I'm an attorney, so I think it'd be fun. If you want to pursue that route, and we will not be doing it personally because we probably wouldn't have the proper standing. If you decide to do it, we'd love to know about it. That sounds like a lot of fun. Parts of the building. So say you have a children's wing and you want to allow guns, but you don't want to allow guns in the children's wing. You can prohibit stuff from certain buildings. So if we posted on these two doors and barred it from this particular room, but we could allow it in the rest of the property. That is an option that you have under this definition of premises. So why might the definition of premises be really important? This photo was taken on the Katy Trail. Since we're in Dallas, you probably know where that is, but if you don't, it's basically in the middle of Highland Park. This was taken I think 2 months ago now. It was in the Dallas Morning News. These two guys generated dozens of 911 calls. 8 units were dispatched. More than 12 officers responded, and 1 off-duty officer responded. Turns out they were toy rifles. They were released without charge, but even if they had been real, they still would have been released without charge because what they are doing is not illegal, and if they had been real, what they are doing is not illegal. Cities are preempted from regulating guns, and carrying long guns in public is allowed under Texas law. This is the open carry movement you've seen about in the paper when someone carries an AK-47 into Starbucks to get a cup of coffee because they want to make a point. So the open carry movement, as I mentioned, they are intentionally challenging improperly posted signs, long guns, antiques, black powder, not illegal to carry. Believe it or not, an assault rifle, an AK-47, is a long gun. This statute goes back to the 1800s before there were automatic weapons, and they've never changed it. So that is why AK-47s are considered long guns, is that, when they wrote the statute in the 1880s, the fastest thing they had was a 30-30 repeating rifle. The statute was made way before modern technology created the kinds of guns that we currently have. However, the regular trespass statute is still applicable. It's a weird thing for a church to think about, wanting to call the police and getting somebody kicked off your property, because you want to be an open and welcoming community. But this is something you're going to have to think about if it happens. If it is your private property, you can have them removed for general trespass. The problem for a lot of our Muslim friends right now is that the sidewalk is public. So they can keep them off the parking lot, but they're still on the sidewalk. And if you think about the architecture of a lot of religious communities, I know the church I grew up at, we parked in residential neighborhoods and walked. Bottom line on something like this is to work with police. You don't necessarily want your church staff or volunteers confronting somebody who's openly carrying with a weapon that looks like this. Telling the police a person is not wanted in the property and having the police deliver that message is sufficient to get a conviction. You can always call the police out to deliver the message for you if you want to make sure professionals are on it and not your ushers and your deacons and your greeters. Like I said at the very beginning, if you are ever in doubt about a situation, be safe and call the police. They told us that is what you should do. We inquired with Austin PD and we said, is this a 911 problem or a 311 problem? And they said it is a 911 problem. It is not the coyote in the backyard for which you're calling animal control. It is a 911 problem. So that is the regular trespass statute that you can still use as you're working with police. I've got a citation to the case in there where it says that the police issuing the notice to depart is sufficient for conviction. There's, of course, other extreme conduct for which you should be aware. This photo was taken outside a mosque in Phoenix, Arizona. These are militia. There are militia groups that are out there. This was back in May. More recently, there was the, quote, Global Rally for Humanity, which was a white supremacist mosque protest. It largely fizzled, thankfully. This was back in October. But the bottom line is, if this arises, call the police immediately. And it is a good practice to develop relationships with your local law enforcement well before you have a problem. One of the things local police will do is they will come out and do check with your local police. I know the Department of Homeland Security, which is federal, the state DPS is also beginning to work on this, and many local police departments will come out and do a security assessment of your building. And what they're looking for is things like lighting and, just looking at the general layout, and they'll give you advice on how to keep your property more safe. It's a good practice to have those relationships with your local police, get to know who your beat officer is. If you're really serious about no guns, then meet your beat officer and make sure they know you have a sign. These are all just good practices. If you have a weird situation like this arise, especially for our Muslim friends and neighbors right now at this time, but really it could happen to anybody, there are other statutes you can work with. I'm going to run through them. You don't have to remember them. I want you to know that there is a thing that exists that law enforcement can use to help deal with a situation. So one of those tools that law enforcement has in the code is the offense of deadly conduct. And under deadly conduct, a person commits an offense if he recklessly engages in conduct that places another in imminent danger of serious bodily injury. So what does that mean? Recklessness and danger are presumed if the actor knowingly pointed a firearm at or in the direction of another, whether or not the actor believed the firearm to be loaded. So what constitutes in the direction of? I looked. It's not really spelled out. It really would be up to a jury to decide. I mean, there's nothing in code that says if I come within a 45-degree angle of Mr. Floyd's head right here, there's nothing like that. It's going to be up to a jury, whether I'm at or in the direction of. But nevertheless, the police know that. You don't have to worry about that. Call them. Another statute is terroristic threats. Threats are not protected free speech. A person commits an offense if he threatens to commit any offense involving violence to a person or to property with the intent to, and there are 3 different ways that they can do it. If you place a person in fear of imminent bodily injury, that is a misdemeanor that they can be convicted for. If you prevent or interrupt the occupation of a building or a place of assembly, which a religious community would be, that is a Class A misdemeanor, a more serious misdemeanor. And if you place the public or a substantial group of the public, which I think any faith community would probably fall under, in fear of serious bodily injury, that's a 3rd-degree felony. So you're getting into felony range. What is a threat? These are really fact-specific cases. I mean, this is like you'd spend a day or 2 in law school talking about was this a threat or not. Bottom line, the police know this. Work with them. Basically, what a threat is to put a person in apprehension of harm, or to put property in apprehension of harm as well. It applies to both person or property. So there's a couple cases, and there's literally hundreds of them, but some of them are fun. This one, the Redfern case, a person was convicted for threatening to release snakes into a building. That was sufficient to get a conviction under this statute. The defendant argued he didn't say poisonous snakes, so the bodily harm was not imminent. The court disagreed. Poisonous or not, there was apprehension of bodily harm, and that was enough for a conviction. For some reason, I find that one amusing. I'm going to threaten to release poisonous snakes in your building. I just find some of these fact patterns amusing, but maybe it's because I'm an attorney. In the Tobias case, a nursing student at the University of Texas at Arlington got a grade he didn't like. And this is a major concern for a lot of our professors these days about campus carry, which is a whole nother topic. But in this case, he got a grade he didn't like, and he took his protest over all the way to court. And he represented himself, which is always kind of a mistake. He threatened the 3-judge panel by writing in a brief to the court, quote, "Given that the courts will not hear my grade appeals or teacher malpractice suits," and I'm quoting him directly, he means suits, "will I have to exercise my right to keep and bear arms to obtain these rights? If so, I will fight, kill, and die to obtain them. This is not a threat, it is a fact. I will have this grade changed no matter the cost in life, money, and time, and yes, after 8 years and $50,000, I am prepared to use gunpoint and death if needed. But before I resort to my guns, I will file at least 2 more suits." Gebhardt, the professor, is lying. I can prove it if I have the chance. My father now has cancer. My uncle has a heart attack. My grandma is 88. Will they live long enough to see me graduate? I hope so, but the decision is yours today. There's obviously some issues going on here. But this is he was convicted. You don't threaten a 3-judge panel. So there are, wow, I know. That's what I said when I read this in the law library. The police know what threats are. So work with them, and they can help you deal with situations as they arise. So I've been talking a lot about the criminal law, the criminal side. In law, there are criminal cases, which involve a loss of liberty due to jail or fine. There are also civil cases. And so a question that often arises is, what is our civil liability based on whether or not we post notice? A lawyer can never promise you won't get sued. Just like a doctor can't promise you won't have a heart attack as soon as you walk out of his office. What a lawyer can promise is that they can minimize your risk and that they can try to get you in a position where it's dismissed as quick as possible, but they can't eliminate the risk. People can sue for anything, and you have to go to court and get a motion to dismiss. So what about private security? This is actually a very safe course of action, and I say that because you are not liable for the actions of an independent contractor. So when you make a contract with private security, and this can include off-duty officers, often they like to make money on the side by doing private security, they are in an independent contractor relationship. And generally, you are not liable for the actions of an independent contractor. Presumably, you hired that contractor because they were competent, and in this case, private security has its own section of code and special training that they have to comply with. So that is a very safe course of action. Off-duty officers volunteering, also a very safe course of action. Go back to the part I said where there's no gun-free zones. An officer can carry anywhere, anytime, for the most part, and in a church always. So what about arming pastors and staff? This is a thing that some do. I would caution on this course of action due to a thing called vicarious liability. So vicarious liability means that the employer is liable for the actions of the employee. And with staff and other clergy, they are employees of the general church. And vicarious liability creates exposure to additional torts, which is additional causes of action that they could, if something were to go wrong, that you could be exposed to. Some are doing it. It's just a thing to be aware of, that there are additional exposures. Civil liability is a concern you're considering. You can, as an employer, under the government code, ban employees even if you don't post notice. So the employer denomination can ban employees from carrying just by policy, and you don't have to post notice to avoid the vicarious liability. And this goes back to the business community, who was very concerned about this scenario 20 years ago. They made sure that this was written in statute so that employers could control the actions of their employees, because they didn't want to get sued for an employee that was carrying and acting in the scope of employment. So premises liability. How is this most likely to arise? It's most likely to arise under a premises liability theory. And the question that often comes up, can we get sued if we post? Can we get sued if we don't post? And so as you're making this decision, people worry about this. So if to go ahead and make the arguments, say we post notice and someone bad walks in and a terrible thing happens. Can the victims sue us because we posted the signs? Conversely, say we don't post signs and a terrible thing happens and a CHL holder screws up and hits an innocent third party. Can we get sued if we don't post signs? What do we do? It feels like a catch-22. There is no precedent to guide us. In other words, in 18 years, it's never come up. As a general rule, you have no duty, and duty is a legal term of art, meaning you have to do something affirmatively. You have no duty to protect against criminal acts of a third party. In other words, someone walks in, it doesn't have to be everybody thinks active shooter. It's actually more likely that it'd be something else, like I'm disgruntled with the pastor or something like that. But it could be any number of scenarios. But someone walks in, does something horrible. That is unforeseeable. It is a criminal act of a third party, and the general rule is you are not liable for it. You do have a duty to use what's called ordinary care. And you have a duty to do ordinary care to protect invitees, which church members are, from foreseeable criminal acts of a third party, if you know or have reason to know of an unreasonable and foreseeable risk of harm. So let's walk through what is foreseeable, because that can really worry some people. It is not, the wildest imagination of what could happen. That's not foreseeable. That's too high a standard a court would never do. Legally, what a court is going to ask when they're trying to figure out foreseeability: were there any previous criminal acts on the premises? That's one factor. If so, there's still a few factors before you get to foreseeable. How recent was that event? How frequently did that event occur? How similar was that criminal act to this other criminal act? And did you even know that it happened? So let's walk through a few examples of foreseeability, because it is actually a pretty high standard. So in other words, the general rule is really the general rule, that you're not liable for acts of a third party. Some examples. In one church in this area, a sexual assault occurred in the bathroom of a church's third-floor gymnasium. There was testimony that was given through deposition of a scuffle or two that were broken up by staff at various athletic events that occurred. That was not enough. A fight at a youth group's volleyball game was so dissimilar from a sexual assault in a bathroom that occurred, after hours, that the court was not going to hold that church liable for that. That was not foreseeable. In another instance, shooting in a hospital parking lot. So a lot of churches have parking garages. Not foreseeable. It was not foreseeable that a criminal act like that would occur in a parking lot, or in this case, a parking garage. A third example, if any of you are from San Antonio or have ever been to San Antonio, there's a shopping center called the Quarry. There was a shooting in the parking lot of the Quarry Shopping Center. If you've not been, it's just a big shopping center. It's not an outlet mall, but it's just a big shopping center that has a lot of different stores that you see routinely. There was a shooting there, and that particular shopping center, the Quarry Shopping Center, they provided security. The owner of the premises provided security, and it still happened. And the general rule there was, no, that was not foreseeable. The risk was too low. The likelihood of injury was also low. And the public policy consequences of putting the burden on the shopping center were just too high. And it was 9-0 in outcome, but 5-4 in rationale. So it was just the reasoning. They all agreed that it was not foreseeable. They just disagreed on exactly the reasoning why. But the general rule, they thought it was just too ridiculous to require shopping center to provide, like personal Secret Service one-on-one security to every person who would come in a shopping center. That was just a ridiculous standard to hold somebody to. So what is foreseeable? So on a particular apartment complex, there were a string of assaults and armed robberies at an apartment complex. In that case, the court did find that the risk of murder was foreseeable. What is the takeaway? So what is the distinguishing factor between this case and the others I showed? Bottom line, don't do nothing. If you have criminal acts that are occurring on your property, don't do nothing. But, and this is an important but, doing something does not mean requiring armed CHL holders. You can hire security, which is a big step. You can do more lighting. You can do a security camera. You can call local PD and ask for a security assessment of your building. You can create a preparedness plan. You can work with law enforcement and ask for more patrols. There are any number of those things you can do that evidence that you're taking ordinary care. In that opinion, when I read it, what the court was really upset with this apartment complex about was the fact that the management did absolutely nothing, and there were multiple armed robberies that had been occurring on this particular apartment complex. It was just the egregiousness of that particular situation. So my point with foreseeability is it has to be pretty egregious. And if you're taking due diligence to try to prevent crime on your property, you're not going to be exposed, most likely. Things to think about. So a good number of congregations will decide to allow this. A thing to think about, however, in the law that they should be aware of is that there are no retention holsters required by law for those that carry openly. What is a retention holster? Law enforcement use them, hunters use them. What it means is with law enforcement, there's a button that you have to push before the weapon retracts from the holster. They do that so that someone can't walk up and steal their weapon and shoot them with it. Hunters will often use it where there's some sort of strap to hold it in, because if you're hiking in the woods, you don't want the gun spilling out. The law does not require that somebody do this. This was actually a big debate that occurred on the Senate floor about whether or not retention holsters were required, and the legislature ultimately rejected it because they thought it was infringing on liberty. So open carry advocates helped defeat the amendments to try to require retention holsters. The reason I bring it up is because just recently in a North Carolina church, a gun fell out in a bathroom stall. And that's a likely place where it would occur for reasons you can imagine, that when you do what you do, things fall out. Keys, coins, in this case a gun. A 4-year-old found it. Luckily, no one was hurt. But this is a thing to think about. So if you were going to be allowing guns, you can, as a congregation, require that they be in retention holsters. It's also a thing to think about because often children run around in hallways. So on the Senate floor, there was a great big debate because in the Capitol, if you've ever been, school groups come routinely in big buses, and the hallways are often full of children. And the thing that Senator Whitmire was worried about was that I don't mean this in the legal sense. So there's a legal thing, attractive nuisance, you've heard this. I don't mean it in the legal sense, but in a just a plain spoken sense, it's an attractive nuisance for like a 5-year-old boy. Ooh, gun. And if you have a crowded hallway full of people, Sunday school's letting out, you're all in the hallway getting ready to go to worship, you don't want a child pulling the gun out and having something terrible happen. So requiring retention holsters is a rational thing you might want to consider. Whatever policy you decide, there is some church-specific inoculations you can take from a legal perspective. So whatever you decide, you can do some things to kind of protect yourself that are available to faith communities. All faith communities, obviously, that can protect you in court. Courts cannot get involved in deciding theological questions. That's the essence of our First Amendment. One of the many essences of that beautiful amendment. Usually this applies to employment law and property disputes. However, it's also applicable here. So whatever you decide, if you entangle your reasoning for your policy with theological reasons, it makes courts refrain from second-guessing your choices. So this is easy for Quakers, right? They just say, we're a peace church, we don't like guns. See 300, 400 years of Quaker history. For other churches, you might want to have more theological arguments. For other faith groups, you might want to have more theological arguments. But if you have theological arguments behind your overall rationale, courts will refrain from trying to second guess your theological positions. They can't do it. A court can't tell you, no, this doctrine is not true Lutheranism. I mean, that's a court, that's establishing a church. A court can't decide doctrine. More practically, check your liability insurance coverage. First of all, do you have it? If you do not, please get it. And I say that not because of guns. I say that because it is far more likely that somebody is going to fall hanging Christmas decorations from an old ladder. That is far more likely a scenario to happen than gun violence, and liability insurance coverage protects you, and it also provides some way to take care of them, because many people in your congregation are on budgets, and a major catastrophic injury can have real cost. People get desperate, and you could get sued. And if you have insurance coverage, everybody is in a better position after a tragedy like that. It is unknown at this time if the open carry bill, H. Bill 910, that we've been discussing, will affect your coverage rates. We don't know. We inquired, we looked. Companies either did not know or did not want to tell us. Predict they really did not know. And they really did not know because while these events are highly catastrophic, they're making the news because they don't happen that often, statistically speaking. They're happening more and more, and it's obviously a very concern. I don't mean to minimize the concern. But still, statistically speaking, from an insurance company and our actuarial's perspective, they don't happen that often. And when they do, they're, of course, but they simply, I think they probably just don't know. We inquired with several different providers, insurance people, and they could not provide us with an answer. The important thing, though, is that you will come to a point where you will have to renew your policy. So at policy renewal time, make sure you check your insurance coverage. Does everybody remember the black mold issue that happened about 10, 15 years ago? So what you want to make sure is that gun violence isn't quietly written out of the policy. You want to make sure that that is a thing that's covered in the policy. You want to make sure that gun violence doesn't become like black mold, that it doesn't quietly disappear from the policy. If it does, we want to know about it. That's a legislative issue. We want to be able to go to the legislature and say, here's what's happening with insurance liability coverage because of guns. We need a legislative solution to this problem because insurance providers are pulling this out from our coverage and we're exposed. That is a major legislative issue that we want to know about if it happens. I'm now going to get into areas that are very gray. And a lot of these are church specific, but these are questions that we've been addressing as we give this presentation. One of the main ones is I'll categorize it as a landlord-tenant issue. So here's the scenario. Many churches, houses of worship, allow their facilities to be used for other community events. And what I mean by that is Boy Scouts, Alcoholics Anonymous. You could have various ministries that occur that aren't necessarily church ministries, but a lot of different events. Like I go to First Methodist in Austin. We're next door to the Capitol. We have people using the building all day long. We have a building use policy. You can address this issue in a building use policy. What you've got is basically a landlord-tenant relationship. It is not one like, it's a little awkward because you don't necessarily have a written lease agreement like an apartment. You don't have people paying rent on a monthly basis. But in law, it's called a tenancy at will. In other words, you're using your building at your will. And so you have building use policies that govern the use of your building. And you can address these issues in your building use policy for those other outside groups like Alcoholics Anonymous or Boy Scouts or whatever it is that uses your building. Another question, and I'm going to start with the clearest and get down into the foggiest. So I'll try to walk you through it slow. Many of our churches have schools. Some are in the same building. Some are in separate buildings. And so the question that arises is it a house of worship or a school? And that's an important distinction because houses of worship are governed under one section of code. Schools, all firearms are prohibited under a different section of code. So the question that we simply don't know the answer to, because it's never gone to court, does a school cease to be a school on a weekend and become a church on a weekend? Is it always a school 24/7? We don't know the answer to that. But if it is a school, generally, no firearms at all, not just handguns, but even the long guns, no firearms at all on the physical premises of a school or educational institution. So say if you got the school in the same building as your house of worship. Is it always a school? We simply don't know. More likely. The issue where it's going to get gray is when you have a school building and a church building connected by a sidewalk. And remember the definition of premises, where the sidewalks aren't covered. That school building is probably covered, but is the house of worship covered? If you want to be safe with belt and suspenders, post notice on the house of worship. The reason it's gray is that there's an Attorney General opinion, a request for Attorney General opinion pending right now at the AG's office. This is a very live issue. So an Attorney General opinion is not legally binding. What it does, though, is it is when legislators request clarification on the law without going to court. It can still be challenged in court. It's not legally binding. The court can disagree. But right now, the ISDs, the public schools, have gotten Senator Whitmire to write a request for opinion. It's pending with the AG over the issue in the part of the code that governs schools where it says, or other grounds. So there's a big debate about what those other grounds are in regard to a school. And so we're watching this because it implicates private schools the same way it implicates public schools. But the public schools are like, well, wait a minute, we have band practice on a parking lot. What do you mean? I mean, other grounds surely covers that, right? And the answer is because there's competing definitions and they've got to have to work that one out. So we're watching that very closely. It is an ambiguity we're currently facing. Here's where it gets even more muddled. We have preschools and daycares. And so you have a spectrum of classification. A certified pre-K that is governed under the Texas Education Agency is probably a school. But a daycare is not. It's governed under the Department of Family and Protective Services. And so really check with, if you have one of these things, check with figure out who it is that gives you the license. So thankfully all these things are licensed, and that's a whole nother long story about how that came to be. But thankfully daycares, preschools, childcare, they all have a license of some kind. Check to see which agency it is that gave you the license. That's kind of the first step. Is it TA? If so, possibly a school. If it's not TEA, it's really hard to argue it's a school. It's a daycare probably of some kind. And then you're going to have special regulations that govern the license. So they're not criminal laws for which somebody could be convicted and fined or put in jail. They're agency regulations that could lead to license revocation. Does that make sense? The difference between a agency regulation that could cause you to lose your license in a criminal law which would have somebody going to jail. That is this distinction we're trying to make here. So if you are a daycare, a situation the daycares are dealing with is that the Department of Family and Protective Services has a regulation in the administrative code that says you have to keep firearms off your property, or you could lose your license. The open question for which we don't have an answer is, does the agency want you to post notice? Or do they want you to just take affirmative steps to remove somebody should they show up with a gun? So in other words, let me phrase that a different way. How is the agency going to enforce that regulation? We don't know. That is a thing we'll be working on with the agency. It's one of the roles of government relations is to try to get clarity on that, but at this time we don't have clarity on that. If you want to be safe and you don't want to deal with a license verification situation, go ahead and post. Obviously, they are big, ugly signs, and that's a community conversation that you'll have to navigate. But the safest route for the daycare is to post, but that doesn't mean that it's necessarily required that you post. It's really a community decision, and it is an ambiguous one that many daycares are currently dealing with. There are some additional resources. We're going to get into the Q&A here in a second, but let me wrap up by saying I'm here, Beeman is here. Email me, and we've been working on these issues. If you have further legal questions, my email is josh, J-O-S-H, @texasimpact.org. Our phone number, I'm easy to find on the web if you Google me. You can call the office, and we've been dealing with answering a whole lot of different questions that people have. Other resources that exist, your local law enforcement are working on this issue. Working with them, they will have resources for you. It is worth a phone call just to meet who your person is and what they have for you. The Department of Homeland Security has resources. And another good resource is Church and Tax Law Report. It is a magazine called Church Law and Tax Report. I found it to be pretty good information. That's just information that's helpful for you to make these decisions. That's all I had planned, but there's probably a host of questions.
Sure, we have time for questions, and I saw various vibrations out there while Josh was talking.
Oh, please.
These are in your handouts.
Sadia, yeah, come on.
Is there a mic in there?
Here, where's the handheld?
Well, these are in your folders, these handouts, which have more information and also a website for those who are not here, who are following online. You can go to www.texasimpact.org/gun-signs-info. Is that okay? Okay, let me just repeat that. There are handouts in your folder, and also for those who are following online, you can get more information at www.texasimpact.org/gunsignsinfo, and it's GUNSIGNSINFO. That information is available also on your website, and I have some questions online as well, so I'll let you guys get started.
Testing. Is this working? Okay.
All right, so questions. Sir?
Just a couple of questions. One regarding the signs, and I think that's a real critical thing. Your sign appears to be about 30 by 48 inches, keeping, rough and minus, but with the 1-inch letters. Are you, in your presentation, are you saying that smaller signs, that there is a potential for a legal gap of argument if it's not the posted size? Okay, and then when we go into a restaurant or anything, or a grocery store, we do see, of course, the emblem, sometimes with some fine print, sometimes without. And you're saying also that that's probably not sufficient.
That's right.
Correct.
So there are many places you probably walked into, like convenience stores or whatnot, that have only this little emblem. That is not sufficient notice under the law. The law reads that it has to have like words in 1-inch block letters, identical being the key word to this. So if you were lacking even one word, in, it says identical in the statute, therefore it would not be enforceable. And there are people out there who are challenging these things. And so, yeah, I think it's, Sadi, do we know the dimensions? 18 by 36? Vague. Is what I
18 by
remember.
36, yeah.
It needs to be in both English and Spanish.
Yeah, I mean, it doesn't have to be 18 by 36. It can be, portrait, not landscape.
Sure.
But it just has to have the exact words in 1-inch block letters in English and Spanish.
And if we have if you will, a front entrance to the church with parking area, and we have a rear area, do you recommend signs at both places?
Yes.
You have to have signs at
It
both
needs to be
places.
in a conspicuous manner. And so if somebody could conceivably enter without having seen it,
Okay.
I mean, physically, I guess not conceivably.
Right, and the gray area for that is there are churches, for instance, that'll have a front door and then 2 doors on the side. We think that if you're approaching from because remember, this is all new, that if you're approaching from a general direction and the doors are fairly close together and you elect to have a sign, you can get away with one sign. But if you have entrances that are open, that are being used on different sides of your church, around corners, etc., you have to post each of those entrances.
Okay, and then jumping ahead, and then I'll get off. Regarding reliability of employees, and the employer being the church, is it recognized that most of us are volunteer parishioners, if you will, holding different offices? Are we considered employees? And does the liability insurance need to be taken a look at in that regard?
That's a great question. I'm trying to remember my vicarious liability class from torts when I was about 10 years ago in law school. That's a thing where I'm kind of your general practitioner doctor, and that would require a specialist, if you will, like an orthopedic surgeon, on all the finer points of when vicarious liability kicks in. It is certainly a gray area for congregations where you have volunteers that aren't necessarily paid, and when that kicks in,
It's an important distinction whether you're directing the actions of those people or not.
that's true. Yeah.
Right? So if basically you say, for instance, we're looking for volunteers to be a volunteer security people for the church, CHL holders come sign up in the narthex, and then you are actually directing those folks to carry their guns in the service of the church, it is more likely that you would be subject to a vicarious liability. If you have a volunteer who's working in the church, you are not posted, and that volunteer is carrying that weapon as a private citizen, you're not directing that activity.
Yeah.
And so those would be the breakpoints. As Josh said earlier in his presentation, there is no inoculation against being sued. But that would be the kind of fact issue that would be considered in that vicarious liability.
Okay. All right. Thank you.
Yeah, in fact, I didn't mention that. That is a thing that many congregations are doing, are these volunteer safety teams.
Right.
Of course, when you start directing actions in that way, you're
Right.
opening up a lot of exposure where people are going to second guess your actions.
If it's happening under the umbrella of a policy of the church, it is
Yeah.
far more likely that a vicarious liability would attach. So.
We received a question from online. You mentioned that the law does not require retention holsters, but the congregations could require that. How would a congregation go about requiring that?
As a matter of policy with your governing board. And that's a part of when Josh was talking about action being demanded, and this is important, and this attaches to this question. It may be that ultimately your church says, we want to do the same thing that we've always been doing, right? But there are a bunch of different grades, as you've seen. For instance, requiring these retention holsters. The specific answer to the question would be the governing body of your church gets together, the people that make that kind of decision in terms of how your property is managed, say, if you're going to be here, you need to have a retention holster, and then you communicate that to your congregation. If we're going to permit you to wear openly, you have to do it this way. But in general, when you talk about action, the action can be deciding not to do anything. The action just can't be not doing anything. Does that make sense? Because this law has sort of forced these sets of decisions into the open, the question is, how are you going to, if you just do absolutely nothing, if you don't consider this in the councils of your church, that is your right not to do anything. But when somebody walks in with open carry and there's a hoo-ha, you guys are going to be starting from ground zero and trying to develop a policy, and that's really tough. And this is extremely important. If you say we're not going to post because we don't want to be in this pattern of speech that this law demands if you post, but we do want to be able to, we take the option of being able to have printed cards and hand them to people and say, I'm sorry, our policy is, and ask them to leave. You can't just do that out of the air. You have to have the actual church governance, whatever type of governance system that you all use in your places of worship, to back that up. So that's important.
It's not posting a sign saying you must have a retention holster. You could choose to do that, or you could just make sure all your ushers know.
Right.
Yeah, it would be a written, probably a written policy that is just in your, however your church does it. Baptists and their hierarchical denominations are different, but a written policy that you then need to enforce.
And then however you decide to communicate it, which could be posting signs, which could be as simple as putting it in your church newsletter, which could be having the written policy available, so if you see someone without a retention holster, you say, I'm sorry, this is something that you need to do.
Okay, thank you.
I've got a couple of questions, and I'm sorry I'm cheating, but I have them on my computer, so is it okay if I just sit here? We've got two questions from, it seems like the same church, Preston Meadow Lutheran Church. One of the questions is, does a church meeting in a school have to post when meeting? Does a school stop being a school on the weekend? And when we run a full-time school that meets mostly through the year with kids, with 95 kids from 6 weeks old through 5 years old. The school goes Monday through Friday, 7 to 5:30 p.m., 7 a.m. to 5:30 p.m. Would this preschool exempt us from the need for an HL conversation by already making it illegal to carry on premises?
Is that a two-part? So there's two
Yeah,
questions?
two questions.
Two questions.
Yeah, let me
from
start
the
with
same
the
church.
first one first. So the question is that ambiguity I was talking about does a school ever cease to be a school, or does a house of worship ever cease to be a house of worship, or does it change depending on the day of the week? So, okay, I've spoken with a couple of different attorneys about this. Our gut is that it never ceases to be a school.
If it is a school as defined in the education code.
Yes, if it is a school as defined in the education code. However, I say that with caution because there's no authority I can point to that says this has been litigated. So in other words, a lot of attorneys think that it is a school and never ceases to be a school, but we cannot say with 100% certainty because a court has not said so. Does that make sense?
We do know that school lawyers have said that a school premises, so those laws that affect a school premises, a school as defined in the education code, they're protected 24/7, 365. That a school lawyer will tell you you can't take a weapon if the school is closed over the Christmas holidays and is not operating at all. You cannot take a weapon onto that school inside that school building, regardless, right? So if your church is meeting at the local high school is a place where you cannot carry, where a CHL person cannot carry a weapon. The preschool question.
Yeah.
The preschool question is a complicated question. and Josh touched on it in his presentation. Preschools are not schools as defined under the Education Code. They're entities described in the Family Code, right? And there is a rule in the code. There's something called the Texas Administrative Code, the rules that are adopted by state agencies for the operations of certain things. There is a rule in the Texas Administrative Code that says preschools are gun-free zones. It says you're not allowed to have guns, and it's an interesting little section. It says you can't have guns, bows, knives, and it's got this sort of peculiar list of distinct weapons that you're not allowed to have at a preschool. However, this is not a criminal law. This is telling your preschool director, in your policies and procedures and your general practices, you can't have these things in your preschool, right? If I am a guy, if Josh is my preschool director, and I am some dude, and I walk into your preschool wearing a gun or having a gun, and the preschool is not posted, I am not subject to the law. I'm in conformance with the law. Josh is out of conformance with the rules in the Texas Administrative Code that have to do with his licensure as a child care center at that instant, right? So it's really weird. And this is important to any of you who have anything to do with a preschool because there is a lot of confusion on this issue. A lot of preschools say, we're a school, you're not supposed to have guns. We know it. We've seen it in our printed packet, in our ring binder it says, right? But what is not clearly understood is that is a legal responsibility on the preschool director, but it has no bearing on somebody carrying a gun into that school. So if I carry the gun into Josh's school and a compliance officer happens to be about, they say to Josh, you have a gun in your school, potentially you're in trouble. And I'm like the CHL guy who says, oh well, sorry Josh. And I walk away and I'm fine. I'm going to say what I sometimes say habitually, which is, does that make sense? But I expect you to say no, because it really doesn't make sense. But do you understand the sort of tension in that definition?
A lot of churches don't have a preschool, but they have like a Mother's Day Out that is not covered by the HSC licensing.
The Family Protective Code, right.
Where would that fall into this?
Church premises.
Yeah.
Just your basic church. It's a ministry of your church. That would fall under the just operations of the church. Right. Yeah, and that preschool thing, pay attention to that, because in my experience already in the faith communities I'm working with, that is come up a lot, and the information is really confused on it because people are saying, we're already a gun-free zone. No, you're not.
I guess there's two terms there that I'm maybe a little confused on, and I've heard you use them interchangeably, is property and premise.
Right.
The sign there says, may not enter this property with a concealed handgun. But what I saw in the slides and your discussion was about premise. What's the difference?
The property is defined in the penal code is the structure and building. And this is a huge problem and a huge issue. The premises is your property can be your property. The property as defined by the penal code related to CHL carriers is the actual building, but not the sidewalk, parking lot. It's the part that Josh talked about in his presentation. The general answer to your question is this is one of the very confused places in the law. It's a very bad gray area. It's bad for employers. You also have the right to talk about your premises, your entire property, right? Everything all the way out to the road where the public right-of-way starts. You can adopt a policy that prevents people from having any firearms on this premises. The deal is you can't post it. They are not in violation just by blowing through a sign. You have to communicate that to them verbally or in writing, and then call the police, and you have that fact issue discussion. You can forbid firearms anywhere, but the magic of the signs only works for structures. Does that make sense? I know, again, it doesn't make sense. And our carelessness of the use of premises and property is actually reflected in the code. That's part of the problem with the code, is that the code tends to use those terms interchangeably without clear-cut definitions.
Yeah, so if I'm a prosecutor, what I convict somebody under is the statute. And I didn't put the relevant part in here. But if I'm a prosecutor, I have to prove the person was a license holder. I have to prove that they were intentionally, knowingly, or reckless. I have to prove that they carried a handgun. I have to prove that it was I did put it in here, on the premises of a church, synagogue, or other established place of religious worship. So the statute says premises under which I'd convict the person. And then further down in this 46.035 is a definition of premises and what premises means. And that's where it says building, not parking lot.
Right.
This is just the magic words they want you to put on here, but this is not what I, as a prosecutor, would convict somebody under. I would convict them for violating 46.035. And so that's where the definition of premises really makes a difference. Does it make sense? No. There was a big fight.
It's a very poor construction.
Oh, very bad. There was
Yeah.
a big fight last session on the campus carry,
Right.
which I should just let y'all know. Beeman also lobbies for the Texas Association of School Administrators, which is the public schools, and also for community colleges. So he's been working this issue on for a bunch of different perspectives.
It is a sad day in Texas when I work for higher ed, public ed, and faith-based organizations, and all I lobby is guns. And that's really almost been true since the session ended with this deal.
Yeah.
But when you but that question of the question that you're asking is really important, because it's important to the understanding of this whole thing. The same thing has happened in higher education, which is the guns on campus and where you can and cannot, by policy, adopt a restriction on guns on campus and not have the character of banning guns entirely on the campuses of public institutions. Same problem, right? It's what is the premises, what is the property, what's the difference between inside a building and a privately owned walkway and a publicly owned right-of-way. But Josh is dead right in terms of the definition specifically for the signage and the CHL holder. Premises is very strictly defined as the building, but not sidewalks, parking lots, etc. The idea is, it's what Josh was talking about earlier, which is the sort of visualized concept when they were trying to draft this law in favor of people carrying arms, was the big box store. Was that you drive to Best Buy, and Best Buy says, we don't want a gun in the Best Buy, but you carry your weapon with you, so you leave it in your car when you go into the Best Buy. If Best Buy can assert that its premises includes the parking lot, then you have to leave your gun home when you go to the Best Buy, right? And so what they were saying is that if you include all of the private property owned by a private entity, what you've done is you've practically excluded people from leaving their homes with a firearm because they can't park. They can't park, they can't walk, they can't really have that weapon with them because they're driving and parking and walking through a patchwork of control that they can't really practically manage. So there's an argument there, right? But it leaves this really confusing thing for faith institutions, because we use our property in all kinds of different ways. We use our property for ministry. Best Buy really doesn't typically use its parking lot for selling TVs. And so our different character creates the problem for us relative to other businesses.
Yeah, so in the campus carry bill, The universities were successful in getting a definition of campus,
Right.
which meant what we would commonly think of the use of property,
Right.
meaning everything we actually own.
Right.
That is a thing for next session because we think the character and nature of religious communities are a lot more like a university campus than a box store.
And that's one of the things that we will probably be looking at with the feedback from the faith communities is basically going with a campus definition rather than a premises property definition for places of worship, if we can get it.
Yeah, and that's a good topic for the second half when we talk about
All right.
upcoming legislative stuff.
Right.
I have two questions about concealed handguns. The first is, we were talking about those holsters, restraint holsters. Does that apply to concealed weapons as well? Is there any safeguard to how those are carried? Just loose in a purse or just in your pocket? Can you make those restrictions for concealed guns as well?
It can be. I mean, physically, in terms of availability, there are retention type holsters that are concealed holsters, or retention. Not to put too fine a point on it, but you can buy a concealed weapon purse or handbag that has a Velcro strap where the weapon is retained in that thing. So the actual physical availability of retention systems for concealed carry is there. Theoretically, you could adopt that in the same way that we talked about before. You could adopt it as a policy that if you're going to carry a concealed weapon, we require you to have a retention system. That there comes a practicality issue there, and that is that if you are carrying concealed in a proper manner, then you kind of never know.
Right.
You know, and so.
That's my second question. You can make a law that says you can put the sign up, but for
Yeah.
17 years, our parishioners may have been carrying those guns and we haven't known it. How are we going to know now?
Right.
I mean, yes, they can be
That's
prosecuted if they do, but
Yeah, and that becomes a weird deal of if you drop your weapon and you know, oh no, you know, I've done the thing, and you've at that point you have violated your responsibility for concealed carry.
right.
If you drop that weapon, and you're no longer concealed carry. But then the question becomes, wait a second, you didn't have a retention holster. And to me, I mean, as a practical matter, I think it would be very complicated to say to try to craft a policy for retention of concealed carry, whereas with open carry, that's a very clear. Yeah, that's a clear concept for people who carry weapons, which is the difference between a retention holster and a non-retention holster. That is that's a pretty clear concept. And let me tell you this, and I will say this as we talk about this, as a nod to those people who do carry weapons responsibly. The fact that you have probably had people carrying in your church and it has been such a small issue is a nod to the general responsibility level of the basic CHL holder. That in general, people who go to the trouble to go to the training and get a CHL take care of it. And one of the first things you learn in a CHL class, one of these sort of postulates or values in a CHL class is having a weapon is a 24/7 job. That you can't be careless. That you can't, that there's a very high level of responsibility associated with the carrying of a weapon. And so we see a lot of people on the news who are these, in my opinion, Wild West maniacs who are out there, but by and large, the middle of the bell curve of CHL holders are very careful and really take that responsibility seriously. So.
Question is just clarification on posting the signs inside or outside of the facility. It's part of we've dealt with this, part of it is, can we post them inside the narthex as somebody comes in the doors, or does it have to be outside on the wall, or is there sort of a general sense of that?
So let me ask a clarifying question before I answer it. When you say inside the narthex, do you mean propped up on something like this, or do you mean like decals on the inside of the window?
Well, part of the challenge is the outside doors are carved wooden doors, so it would be on the wall as you walk in, right there on the sides too. I mean, that's the other issue you mentioned. We have entrances this way, forward, and so that comes to 3 signs in the narthex. We have glass doors in the rest of the building and other places.
So the law allows you to prevent carry in certain portions of your building, if you recall the definition of
Correct.
premises. So you want to cut off the children's wing, but not the rest of the building.
The real question for you would be, if you put them in your narthex, but that constituted a visual space that gives access to the whole rest of the building.
Well, we're anticipating having to put up 13 signs that would cover the Sunday morning doors open. We've already voted on 30-7 that we will not allow open carry. We didn't fight the battle of 30-6, so we know we're posting that. But on Sunday, during the week, we have one primary door that's open. But at Sundays, we're looking at essentially 12 to 13 doors if you're coming into the building that we would have to cover.
So
but I'm thinking of the sanctuary primarily, the trustees talked about, so we have to post these outside on the pretty walls or inside on the pretty walls?
Yeah, the signs basically are are informing the public of your policy, right? And so it's not like the signs create a magic line.
Right.
So if they're a place where it is reasonable that a visitor would see them. If they're in the narthex, you can't walk in the narthex and say, well, I can't go past this sign, but I can have the weapon right here. It would still work to say, oh, I'm not supposed to have the weapon in here at all. That's what I think.
You could, yeah, it's kind of interesting. It's kind of gray if you could walk in the narthex
Yeah.
and stand there with a gun or not. It's
Yeah.
kind of gray. I mean, a thing you can do is you can just, if it's a Sunday only door, is that what I'm hearing? It's a door you only
Correct.
keep open on Sunday. You can mount it to something you just take outside and bring in when you lock it. Does that make sense? Like
It does.
a portable sign that you don't have to affix. Or, I mean, you could do it the narthex way too. It's just know that somebody might be able to have a defense if they walk into your narthex and stand there.
Yeah.
Right. My understanding with the
It'd be weird. But
concealed weapon, though, if you have knowledge, like if you walk in and you see that sign and you have knowledge, it's
Yeah.
your requirement.
It's
to
your
leave.
requirement
yeah,
to
you
walk
have a
out.
duty to.
You have the
you have a duty
So,
to take
okay.
off.
So that helps.
And that is actually what is not well litigated is how moving signs might work in a premises. What is well litigated is your duty once you understand that there's a policy on the premises to get out.
Okay. And employees policy, we would just need to create an employee policy, even though we have only, trustees have voted for 30-7. If we wanted to not allow employees to carry concealed, we can do that as a church
Correct.
policy, correct?
You can say employees can't have guns at the workplace.
Correct, okay. And the other question I have is, what had to do with the insurance and the, sort of related to that, do we have a greater risk than if, vicarious liability, I guess, if employees are carrying concealed weapons? Because, I mean, does that sort of open up our liability more because they are employees?
That is so hard to say, right? I mean, again, we've had this since 1997, right? The CHL since 95, in churches since 1997. You're talking about and from an insurer standpoint, there is no data on this. Yeah. I mean, there's no actuarial. There's really no, and until there is a raft of incidents and a corresponding raft of lawsuits, which there have not been. There's really not a way for an insurer to make an actuarial valuation on this change in the law. And so I would be very surprised that if anything you do related to this has any kind of impact, positive or negative, on your insurance rates until such time as you get enough and God forbid, that you get enough statistical action for them to be able to make an actuarial determination on.
Last question. The biggest thing that our trustees and our ushers and everyone has had in this conversation has been, the trustees, for example, we don't want to put our employees in harm's way. So if we have somebody come in with open carry, the big concern is who addresses them if they don't address it. For example, we have about 150 ushers. We have 30 employees.
Right.
I mean, is it only staff that's going to do that?
That is a policy of your church, and you really have to.
Right.
You really have to basically do your self-examination on that and decide who would be, comfortable is not the wrong word, who would be willing to do it and could do it with the appropriate confidence.
Yeah, and it's also appropriate to call the police immediately.
Correct.
If you've got a 3007 sign and someone walks in with open carry,
If you've got a sign.
you don't have to confront
Will.
them
Yeah.
at all. You can have the police do it for you.
Yeah, if you've got a sign, if you've got a sign, I would strongly urge you just to call 911, because if somebody blew the sign who's a CHL holder and walked the sign anyway,
Open carry, yeah.
that is not a good sign,
Yeah.
right? You would need the police on that. If you decide not to, and this is something that my church is struggling with, if you decide to have the policy as a card available, and you decide not to post the signs, but you decide to inform people if they come in with open carry and say, I'm sorry, we don't allow open carry here, here's our policy, then you have the issue of determining who the proper person to do that should be.
But if we have 3007 posted and someone comes in, and our question really is, if somebody comes in, maybe they didn't see it honestly.
Yeah.
Do we say, by the way, did you know this is a no open carry? And they say, largely number of people, I hope, would say, oh, I'm sorry, I didn't know, and leave.
Right.
Or if they say, I don't care, then our response to everybody in our discussions has been, if they say, I don't care, we just say, thank you, walk away, and call the police.
Absolutely.
But that's sort of the thing. Do we confront? Do we confront it at all initially? Because it might just be an oversight that they didn't see the sign, but, or something.
The police advice to us. Yep. The police advice to us is, you call the police. What they say is, and this is what we've been working with a guy who is the associate commissioner in Austin, who is in charge of all the patrols north of the river and all special events, and I mean, this is the guy in Austin. And what he has said is that he has never seen a CHL holder intentionally imperil that license, right? And that part of the training in CHL is your own situational awareness, that where that you're looking for that sign, that you don't just walk in and sit down with a weapon and then say, oh, gee whiz, I didn't see it was push instead of pull. I mean, you're supposed to be looking for that. The policeman's advice to us, and I think it's good advice, is if you are posted and somebody blows through that sign, that's a cop thing. If you are not posted and somebody comes in and sits down against your policy, that's when you're in the area of, in fact, you have a responsibility to be the first person who talks to that person and says, I'm not going to call the cops and ask them to escort you out. I'm going to inform you of our policy, and then if you don't adhere to that policy, I'm going to call the cops, right? And so that's kind of where you are. But the police would advise you, and I think it's pretty good advice, given what we talked about earlier, that most CHL holders are actually quite responsible with that privilege. That if somebody is being clearly irresponsible with that privilege, that's a problem.
Yeah, and police do have some discretion in enforcement. And if you're saying it was an accident, don't prosecute them.
The dude just says, oh my gosh, I can't
You can't
believe
promise
it.
what the police will
Right.
do, but there's
Yeah.
nothing requiring them to haul them off
Yeah,
to jail.
if the guy's the most surprised guy in the world and just really spaced the sign, there's discretionary room for both you and the police to deal with that. But caution would suggest that you get the police involved.
First of all, I do want to thank you for presenting this, because I'm new to Texas. I'm just started an interim position in Amarillo about a month ago, and so
Most people here are totally sane.
Excuse
Promise.
me. Yeah, and so I'm just sitting here trying to sort all this out in my brain and how I'm going to discuss this with the council, because it has been, it is on their agenda. We have to deal with this. So in terms of the question of ordinary care, the setting I'm at does have a security system in place. The doors are locked. We do have security cameras, because we have had other kinds of instances of threatening behavior by people off the street. So this has been established already, and which I think is a good thing, given our location. We're right off, of Interstate 27. And so in terms of if the congregation decides not, for whatever reasons, not to post signs, given that they have taken ordinary care provisions, would we, if in the unlikely event that something should happen, would it be regarded as, well, you did take ordinary care, or do we have to have the sign?
No, I think you've taken ordinary care.
Excuse me?
I think you've taken ordinary care. I mean, there's nothing in precedent that I can say 100% for sure.
Right.
But because there's no precedent, and you've taken these affirmative steps,
Yeah, the two
I
questions.
think you've been responsible and done due diligence.
Right, and the two questions, remember, there's also the question of foreseeability, right? So the two questions are, one, are you taking general ordinary care for the safety of those people that you're inviting as visitors into your space? And the second question is there a fact pattern of something happening that you are not responding to, right?
Okay.
So have you had a bunch of trouble and you're just saying, oh, well, that'll probably never happen again? That's an issue. But if you don't have a fact pattern in the past of things that create a foreseeability of issues in the future, you're probably fine.
Yeah, looking at the few little precedents on other fact patterns that exist, the one that the court upheld was when the people did absolutely nothing. And you have not done absolutely nothing.
Right, okay. And, looking at these two, I'm a Second Amendment guy, and I believe in our rights to protect ourselves as such. However, I'm looking at these two, and if I were to recommend, I could see it'd be reasonable to recommend not to allow open carry, because while I believe in my rights, do I have to flash them? Because if I open carry, that immediately, as we all know, brings whatever attention, wanted or unwanted, to it. And is that the kind of atmosphere I want to have in a worship setting? And so
Right.
that'd be the only, a reason why I may recommend not allowing open carry, which gets into other issues about concealed, but oh well. The other question is, for clarification, because this law is taking effect, does this put a congregation into the position we have to decide something or not and go on record as deciding, or is a congregation free just to let a sleeping dog lie? Because, but if they do that, does that put my setting in a more complicated situation should something happen?
I'll answer that. It's a wonderfully free country, and you can do absolutely nothing in terms of the law, and even I think in terms of liability associated with the law. Because again, it's not like your church has a pressing need for something, for weapons or not weapons or anything, as a function of a previous fact pattern. Our advice about doing something has a lot more about the foreseeability, not a foreseeability of criminal activity, but a foreseeability of somebody doing something, somebody essentially walking into the church with open carry, and suddenly it's an issue before you that you haven't, that it's foreseeable that there will be an incident that will create discussion in your church. It's not foreseeable that there will be a criminal act in your place of worship necessarily, but it's pretty highly foreseeable that it's the responsible act of a governing body to talk about this before you're forced to talk about it by somebody walking in with a weapon and creating a hoo-ha. In terms of your other observation, and I think this is important, right? There are all kinds of, one of the reasons that we bombard you with this incredible avalanche of facts today, instead of saying, here's what you need to do, is that this is really a subject that you need to talk over with your congregations. There are a bunch of, as I'm sure all y'all know, as people of faith, there are a bunch of religious questions associated with this. There are questions of the culture of worship and the space in worship. There are cultures of civil behavior between your congregants and what makes people comfortable and what makes them uncomfortable. And there are issues of legal liability, as we've talked about here a whole lot. But all of those things are in play. And it is a very strong, one of the things, if we found out anything in our own deliberations about this, it is that a gun means such different things to different people. I mean, it means such different things to different people. And some people see them as a very familiar tool, and some people see them as a thing that is a cascade of political and ideological emotion and everything else, right? And it's an amazing thing that a single object can mean such different things to such different people. And that is probably really at the heart of our deliberations, is how can you actually solve that tension in your congregation when it is a thing that means such different things to so many different people.
You spoke of tenants renting from church owners, but what if a church is a tenant of a private property and the owner of the private property chooses to not do this? Can the church, during its usage of the property, prohibit open carry?
Oh, that's a good question.
I don't know.
Well,
That's a great
okay,
question.
I'll repeat the question. A church or a congregation
Right, and actually
is leasing space from a landlord, and the landlord does not have a requirement. So it is a landlord-tenant relationship, and if it's silent, then you probably want to meet with your landlord to see if it's okay or not. He'll probably have some concerns about screwing holes in his building or her building, but it's a thing you need to work out with your landlord primarily as to how you go about handling it.
And that's an amazingly interesting question, right? Because it's going to come up in multi-site, for instance. Those congregations that are participating in multi-site programs, that's going to be a real deal. And I would be very interested to find out if a landlord who was a person who felt very strongly about the Second Amendment said, well, if you're going to rent from me, you can't post those signs. And what in the world that would mean? So it's, I think you are, as Josh said at the opening of his presentations, we'll go out more, confused in a more enlightened way, and I'm sure we'll get a question that we haven't heard, and that's a new one, man.
Yeah, my suspicion is that it's a landlord-tenant relationship issue.
Yeah, a contractual issue, and would be a contractual issue in the lease.
Yeah, and
in
so
the agreement
however
to use
that's
property.
resolved, let me know. I'm kind of curious. I want to know for legislative reasons, because it'll arise in some way where that'll come up. That's a very interesting question. I think it's a landlord-tenant thing that has to be worked out in a lease agreement between you and the landlord.
So we finished the program on an epic fail, with us not the morning program anyway, and I think we're good. All right. Yeah.
I want to invite you to thank Texas Impact for the presentation. Thank you so much. Obviously, this is a very timely topic for us, and your information was really important for us to hear. We've got many live stream viewers in addition to the folks that are here, and we are recording this session. So if you need perchance to refer back to something that was said, you will be able to access that through our website. So as I said, we're going to take a break. Lunch is being served at Shalom Center. You'll just leave the front of the building and walk to your left, and you'll see Shalom Center just on the dirt road on the right-hand side, near the pool is where that dining hall is located. We will reconvene here at 1:30 this afternoon and begin our presentation again. And again, it will go as long as you guys have need, and if we end it earlier than, say, 2:30 or so, that's fine too. I'm sure everyone won't mind being on their way. But I thank you for being present with us this morning. Let's close with a word of prayer as we pray for our meal. Good and gracious God, we give you thanks for all the information that we have learned this morning as we desire to keep those in our faith communities safe when they come to be with us for worship or fellowship or celebration of any kind. Help us continue to provide communities and spaces where they can feel welcome, feel protected, and to know your love in its fullness. As we make our way now to our meal, we give you thanks for the food that is provided. Ask that you bless it and bless this time of renewal and conversation around our lunch tables. In your name we pray. Amen.